Good evening, ladies and gentlemen. Today, I am very pleased to introduce a very special subject and guest, dear Harry Teming. He joins our meeting from Brussels. He will make his remarks on an action plan published by the European Commission recently. Mr. Harry Teming works at the European Commission. He is currently the Deputy Head of the Intellectual Property Unit at the Directorate General for Internal Market, Industry, Entrepreneurship and SMEs at the European Commission. Harry has a Dutch law degree from the University of Utrecht in the Netherlands. In addition, he holds a Spanish language and literature degree. He joined the European Commission in 2003. Since then, he has served in various units of Commission. He worked at the Industrial Property Unit at Directorate General for Internal Market and Services between 2003 and 2008. Afterwards, he worked as a member of cabinet of Mrs. Magdalena Kuneva. He was the European Commissioner for Consumer Affairs in the cabinet until 2010. In 2011, he was appointed as a deputy head of the Online and Postal Services Unit. After 3 years working here, he served as a deputy head of the Public Interest Services Unit till 2017. Previously, he was a lecturer in public economic law at the University of Utrecht, an advisor at the Netherlands Competition Authority, and legal secretary to the Court of Justice of the European Union. Harry, I would like to extend my warm welcome and thanks for the valuable information that you will provide. If you could briefly introduce yourself and make your remarks on the action plan, I would be grateful. Later, I would like to raise some questions from my side, and then we will answer the questions raised by the audience. Okay, Harry, floor is yours, please.
Okay, thank you very much, and hello, good evening everyone there in Ankara or the rest of Turkey. Let me say first that it's good to see you back, Arzu. I have nothing to add about my own, except that obviously we have known each other already since 2003. We met each other for the first time in Ankara in 2003. And time goes very fast, actually, but it's always a pleasure to see you. And I'm really grateful that you have given me the opportunity, actually, today to present the IP Action Plan of the European Commission. That's a policy document that we presented as European Commission on the 25th of November last year. And the aim is indeed that I will take you through this action plan and actually explain to you what the Commission is going to do in the next 2 years. Yeah. Now I've prepared a PowerPoint presentation, and we agreed that first I will do my presentation, 20-25 minutes, and afterwards everyone is free to ask me any question about IP, the Commission, whatever you want to know from the European Union, right? So let's do the critical part now, which is actually that I share my screen with you, and that should go fine. Voila. And there we have it. Okay. Yeah, you can see the screen. Okay, it's only 8 slides, so I hope that people don't get bored because of slides. I promise you, it's only 8 pages, and that should be okay, actually. All right. So let me check. Yeah, you can see this. Go back here. Oops, now I do something wrong. Don't worry, it will come back. Voila. No, this one. Voila, here we are. Okay, so the European Commission Action Plan on Intellectual Property. The first question that we then always have to ask ourselves is, why on earth is the Commission coming with an action plan on intellectual property? Because there is already so much law and policy on intellectual property in the EU. And the question is actually quite simple to answer, in the sense that we may have already a robust system of IPR protection in the EU, but there are a lot of challenges ahead. And you will see these challenges now coming on your screen. First of all, despite the fact that we are already legislating in the EU for many, many years, there is still quite a lot of fragmentation of IP laws in the internal market. And the only example that I have to give to you that you all know about is the unitary patent. We still do not have a unitary patent. So if you want to have protection in the EU, patent protection, you can go to the European Patent Office, of course, which will then give you the opportunity to get patent protection in 27 member states. But once you have the patent, the enforcement and all the rest of it is an issue of national law. So that is a clear example of inefficiency and also of fragmentation of the internal market. There are more examples, but this is the one that I would like to give to you. Secondly, you see insufficient market uptake. According to our evidence, according to the studies that we have made, it turns out that SMEs in particular, smaller businesses that have IP rights are doing better economically than those SMEs, those small and medium-sized enterprises that are not having IP protection. So apparently there is a link that if you have IP protection, you perform better economically. You are certainly more innovative when you have a patent, for instance, than when you don't have a patent, according to the evidence that we have, right? Third issue then is the access to IP. Now, this is a different issue. One issue is whether you go or you don't go for IP protection as a business, but the other thing is then once you have a patent, or you have a trademark even, or whatever you may possess, what are you going to do with it? Yeah. And what we would like to promote, what we see as an issue is that those who are owning IP rights, they can explore and make use of these IP rights actually much better than what they do right now. So we are actually in favor of exchange of information through patents, yeah, and other IP rights. Another example of an area where we still have quite a lot of challenges is the issue of counterfeiting and piracy, right? Despite all the efforts that we have made, we see that there is still an increase of counterfeited products, sold both offline as in the past, but obviously there is a new challenge, and that is the rise of counterfeits that are offered online. And finally, what we have as well as a challenge is the global dimension. We are not alone in this world. There is even more outside the EU than there is inside the EU. So we have to see what our role is actually in the world when it comes to IP policies. And there actually we see that there are issues that are happening in the world we are quite unhappy with, and we would like to contribute actually to improve the situation, not only within the EU, but also outside the EU. Yeah, sorry. So this is in a nutshell why we believe there should be an IP action plan. But in addition to these IP-specific issues that I mentioned, I should mention 2 or 3 more elements that are very important these days here in Brussels. One element is that whatever the European Commission is doing these days, we always wish to contribute to 2 major transformations. One transformation is the digital transformation, and the other transformation is the green transformation. Yeah. In other words, the economy has to become more green in order to reduce the environmental burden that we are all creating. And the question then is very simple. What can the IP system do actually to contribute to these 2 objectives? The objective of digital and green transformation. Yeah. And finally, there is, of course, since last year, another challenge that we are having, and that's the COVID-19 and the subsequent economic and even financial crisis that we are facing all over the world, I believe. Well, if we do an IP action plan, then obviously we should also make clear actually how the IP structure can contribute to the resilience of EU businesses, but also actually how it can contribute to end this pandemic that we are all suffering from. Yeah. So that's the starting point. Then the question is, okay, so what do you actually propose, and how did you how did you prepare that IP action plan? Well, the preparation has been quite straightforward. We have within the Commission created a sort of a task force, put it that way, actually, that prepared the IP action plan, which means that it is not only an action plan dealing with patents or trademarks, but that it is actually covering all the IPs and covering all the services within the European Commission, including, for instance, geographical indications, but also we have a strong link actually with the research activities that we are pursuing and that we are funding in the EU. The external dimension, I already mentioned it, from DG Trade. So we worked actually together, all of us, to come forward with this IP action plan. And in that context, we also consulted the outside world, the businesses in Europe, the member states. We have extensively reached out to any interested party in the EU and outside the EU that could have a say about how the IP system should be shaped in the future, in particular in view of concrete actions over the next 2 years. Yeah. So I should mention now that in this presentation, for the rest of it, I will leave out copyright, not because copyright is not important, but simply because copyright, there has been a serious copyright reform, and that ended 2 years ago. The new copyright directive, those of you experts in copyright are aware of. We are in the process of implementing the new rules. Some of you may be aware of this famous Article 17 that should be a basis for peer sharing platforms like YouTube to pay a fair share actually of all the music and all the content that they are transmitting to the right holders. Yeah, that's Article 17, and that requires a lot of resources already for the copyright unit in DG Connect. And so we have relatively minor ambitions here for the copyright field. Yeah. For the rest, you will see that we have 5 pillars actually to address the issues that I mentioned before. And in the next slide, actually, what I will do is I will give you concrete examples of where we are heading to for all of these 5 pillars that you see here. And I go from I can actually use this nice laser point here. So you see I go from right to the left. So first of all, better IP protection, improve the ways that IPRs are protected. That's more the traditional legislative part. Easy access and sharing of IP content, the effective use and the deployment of IP, so the taking up of IP in particular, but not exclusively by SMEs, as we talk about research institutions as well. The fight against counterfeiting and piracy is one major issue, and then the global dimension, the EU as a global standard setter, as you can see here. Yeah. So as I said, in the next slides, what you will see is more concrete examples of what we are proposing. So let's go with the first slide on this, where you can see 2 themes. The upper theme is actually the reform of the design protection in the EU. As you may be aware, we have a directive on designs that harmonizes the national regimes for design protection. It's a directive of 1998. And we have a regulation as well on a community design, so a design that gives you protection not in one jurisdiction in the EU, but throughout the EU, a single title, the community design, as it is still called. And obviously, that's a long time ago that these rules were adopted. And after 20 years or more, it was necessary to do an evaluation, which we did, already completed. And our conclusion is that the design system, as we have it in the EU, is still fit for purpose, but there are certain shortcomings that we will have to address. Yes, so what kind of shortcomings I'm talking about? Well, the registration procedures, they can be improved, taking into account, of course, the digital developments that we have seen since the beginning of the years 2000, the protection of new forms of designs, like animated designs or graphical user interfaces, how to present them to the IP office, The impact of 3D printing, for instance, is an issue that is considered important. And finally, last but not least, possibly the most sensitive issue in this context is the liberalization of the spare parts market. Now, the European Commission already tried to liberalize that market in the years 2000, 2004, 2006. We did not get a qualified majority in the Council and the approval of the European Parliament, and that is why actually we dropped the project by then. But now actually there is a new momentum to liberalize the spare parts market, in particular because in two major countries in the EU, Germany and in France, they are working already on the liberalization of that spare parts market. Now, it's done differently in France and in Germany, I know, but still, I mean, obviously we have to see how in this reform that we are preparing, actually, we shape the liberalization of the spare parts market. Now, in timeline, in terms of timeline, well, we have recently published a kind of a consultation document that we call an inception impact assessment, for which everyone could actually give its view and say, look, you should do, in the future, the reform should look like this, this, or this. We got a lot of feedback from interested parties, which we now are analyzing. And on that basis, we'll make an impact assessment, and the proposals will probably come by the end of this year. So you can write down in your agendas, end of the year 2021, European Commission will come forward with a reform of the designs regime in the EU. Yeah. Now the second point, geographical indications. There we have two elements. First of all, we have a system of GI protection for agricultural products. You are obviously familiar with. The EU has already a long-standing regime. Since the 90s, we already protect GIs. The trouble is that the system is quite complicated, and there is actually a room for improvement there. So here we also have made an extensive evaluation of the system, and the conclusion is basically as with the design protection, generally fit for purpose, but there are some shortcomings that we will address in a reform of the GI regime for agricultural products. And here again, we have done an inception impact assessment, the same procedure, and you can expect the Commission to come forward with a reform by the end of this year as well. Yeah, reforms meaning that we streamline the different procedures that exist now, and we see how we can improve, as in particular, actually, the process of the management of the applications, and you will know more about it by the end of this year. Now, under B, you will see that I have put another example, and that's something new. That's something you haven't seen before from the EU, and that's the creation of a possible creation. I have to be careful here. The possible creation of a system of EU GI protection for non-agricultural products. Because so far that has not been created at EU level. We have it in a number of member states, like in France or in Poland, but we don't have it across the board. And we are now seriously considering whether it is not necessarily actually to create a sui generis system also for the GI protection for non-agricultural products, amongst other reasons, because Article 22 of TRIPS doesn't make any distinction between the two types of products. And also because recently we have adhered to the Geneva Act, and in order to benefit entirely from that accession, it may be useful if we create a sui generis system for GI protection for non-agricultural products in the foreseeable future. And here we are preparing an impact assessment again, and we hope to come forward with a proposal also here by the end of this year. So you will have, by the end of this year, if all goes well, 3 proposals from the Commission for reform on design protection, on GI agricultural products, and GI non-agricultural products, where we will possibly create a brand new system. Yeah? All right, I hope you're still there. We go to the next slide. And that's actually not so much on the basis of the the structure that I indicated before, but simply to make it a bit more easier actually to explain what we are doing, right? So here again, we have two bullets, yeah? And first bullet is, of course, the bullet of the SMEs. You will agree with me that it is vital that our SMEs are aware of the added value that IP and IP protection can give to their business, and that for that to become more fruitful, actually, to become to have a better IP protection for SMEs. First thing you need to know is of course that the SMEs are aware that there is something out there like intellectual property, right? And for that we need good awareness tools. And what we are creating now is actually a one-stop shop, as we call it. So one single point of entry where all the existing elements of awareness and information that you can get in the EU about IP, what it does, where you can get protection, how you can get protection, what happens if you are subject of a violation of IP rights, all that kind of information. We put that into one single platform, this so-called European IP Information Center that will be developed by the EU IPO in Alicante. And that is should then bring us a one-stop shop of information on anything that SMEs need to know about IP. The next point under B is something that is related to COVID-19. It's something completely different. Huh? But let me explain it briefly to you. So obviously, what we see is that since the outbreak of the pandemic, COVID-19, March 2020, and March 2020 last year, we see that there has been a drop in the registration of IP. Not so much perhaps for the time being in the area of patents. Now there is a fear that it might go down. What we have created now, and which has a system that has become operational since January, since a few weeks ago, is a system of IP vouchers. So what we are going to do is, as EU, we have reserved 20 million euros together with the EU IPO, actually to give to SMEs that are interested in having a reduction for their application fees for trademarks and designs, or SMEs that are interested in having strategic IP advice, what we used to call pre-diagnostics services, or maybe that sounds even easier, an IP scan. SMEs that are interested in an IP scan. SMEs that want to know, okay, I have a business, I have no idea about IP. Can you please inform me and advise me whether IP protection is relevant for my business or not? Because obviously it's not relevant for all the SMEs, right? If you are, let's say, a butcher around the corner, you may not have less interest in IP protection. But if you are an innovative company in the area of technological solutions somewhere in the environmental field, then there's a different story, of course. And we enable you now actually to get up to 1,500 euros, and which you then can spend either on a reduction of fees or on this IP scan. Yeah. All right. Okay. And then under C, IP assistance in public funding programs directed at SMEs. That basically means that when we, as European Union, give public money for research to businesses or to research institutions, what we are aiming for is that every time you get money from the EU, you also get free advice about the necessity to protect IP or not. So this is a bit in line with what I just explained with this IP scan. You get a free IP scan no matter how and what when you get public money from the EU, whether you are an SME actually or a research institution, that does not matter. Right. Okay. Now this is the box SMEs. We care about SMEs. Now, the next box is here is new technologies. I already explained, digital transformation is very important these days. And the question can then be raised, what is the impact of these new technologies on IP and on the IP system? Is the IP system still fit for purpose in view, for instance, of the development of artificial intelligence? Yeah. Well, it's a hot issue, I think. There's no conference, a decent conference these days anymore, or there is interest for artificial intelligence. It has also become an important agenda item for WIPO, and correctly so, we believe. Now, what is our view on IP and artificial intelligence? Our view can be summarized as follows. We believe that the IP system generally is fit for purpose also for artificial intelligence inventions. So there is an interesting saying in English, if it ain't broke, don't fix it. Yeah. So we don't think that the IP system is broke because of new technologies in general and artificial intelligence in particular. The IP system, in our view, is consistent enough actually to incorporate necessary adaptations to new technologies. So that is actually our basic line. It's not because we have development of new technologies that we should immediately start to change the IP system, because over the past we have seen that the IP system is robust. Yeah. However, it may be useful sometimes to give some guidance to explain better, to clarify how the IP rules have to be applied in the context of new technologies. And here we have examples here already in the area of, for instance, patents, the ownership of a patent. Can artificial intelligence systems be the owner of patents? Well, we know actually from practice from the EPO, the Dabus case, and that the answer is no. You need to be a physical person or a legal entity or whatever, but you cannot be an artificial intelligence system and get IP protection. So this kind of issue is solved actually by practice, I would say. It doesn't really need a major reform of the IP system. But okay, it is actually good to see what happens in practice, to monitor these new technologies. And in some areas, it might be necessary that you have a legal amendment, in particular when it comes to digital directives like the database directive in the area of copyright. There, of course, after so many years, but not only because of new technologies, also for other reasons, we believe that it's time for a revision. And we may also have to clarify. For instance, we are considering a clarification of the Trade Secrets Directive in order to enable, in particular, the sharing of information. Trade secrets, in principle, you can say, okay, trade secrets and sharing of information almost seems to be a contradiction. We believe it's not. On the contrary, we believe that the Trade Secrets Directive makes it easier actually to share information, and obviously sharing information is easier because of new technologies. Yeah. Okay, I see we are already basically running out of time, so let's move on a little bit. I do the rest then a little bit more quickly. This is the box with patents. Patents, obviously, the unitary patent, that's our flagship initiative, I would say. And, well, we haven't yet managed to let it become operational. The reason is very simple. For the unitary patent to become operational, we still need the ratification by a sufficient amount of member states, a sufficient number of member states of the unitary patent court system. We are still lacking one major ratification, and that's from Germany. Now, the German ratification has been delayed because of the cases that we have seen before the Constitutional Court in Germany. Now, we hope that the problems will be solved soon. We have had a new draft law in Germany both approved now by the Bundesrat and by the Bundestag. Of course, we have also seen now very recently a new case in front of the Bundesverfassungsgericht, so the Constitutional Court, but we hope that this will not be taking so long as it did in the past, that actually the Gerichtshof will quickly now give a verdict. And then we can essentially start. There are still other other issues that we still may have to deal with, and the provisional application agreement, for instance. But I think once we have German ratification, the point of no return will be reached, and we hope that by 2021 or 2022, actually, we can become really operational with the unitary patent system. Yeah. Okay, second point here, that's the SPC issue. Very briefly, we have already seen a slight reform of the SPC system 2 years ago when we approved the waiver for SPCs. We have done an evaluation of the SPC system overall, again, here as well. Our conclusion was the SPC system is still fit for purpose. There's no need for big changes. Perhaps we can improve the transparency and we can make it easier actually to have the registration procedure, which is now a pure national issue. That's not very helpful if you have to go to each and every country actually to get your SPC. That's not very helpful. Maybe it's better to have a sort of a uniform granting mechanism for the SPCs, and we are considering that. Yeah. Then the third issue here, not unimportant, is COVID-19 in view of obviously the patents owned by the pharmaceutical industry, those that are in the luxurious situation to have found a vaccine that works against COVID-19. Well, you may be aware that then in many states, in many parts of the world, actually, immediately the question comes, should we not actually take away the patent from these businesses or at least force them to license the innovation to whoever is interested in producing the vaccine? Well, our view on this is clear. We believe that the patent system is fit for purpose also in times of COVID-19. So here again, we believe that the system works. Member states or states in general have the option, of course, to issue a compulsory licensing, but we believe that member states should use that option in a cautious manner due to the balance in the system. However, if there would be a member state in the EU that issues compulsory licensing, then we believe that we should at least have some transparency about it, exchange of information about it, knowing, of course, and respecting the fact that compulsory licensing is in principle a prerogative of the member states, not of the European Union or the European Commission. Yeah. And finally, in this box of patents, possibly the most conflictuous or sensitive initiative that we are proposing, and that is the any initiatives actually in the area of standard essential patents. Now, obviously, we could spend a whole hour on this. Standard essential patents have become increasingly important, in particular for the Internet of Things. There are increasingly companies, SMEs as well, that are confronted with standard essential patents when they want to develop a product. However, there is still, in our view, a lack of of the friends conditions, and we have done a study on essentiality checks, and that study has been published recently as well, which we are now discussing with businesses. And our next steps are essentially two ways. On the one hand, we like to continue to be in contact with the industry, both the implementers and the SEPS holders, to encourage them actually to find a solution amongst themselves. That is, of course, a starting point. We could help them maybe by giving more guidance, for instance, on the friend conditions. But essentially, we believe in the first place it should be industry-driven, the initiatives here. However, if that would not work or not work sufficiently enough, then we still have the option of coming forward with legislation. We do not exclude that. We don't say that we will. Depends on how the developments are. But we will not exclude that we come forward with a binding instrument, a regulation, for instance, to improve the transparency of the SEP's procedure, in particular in the part of the essentiality checks, and also to provide some tools actually to industry and to standardization institute and IP officers actually to in the area of the essentiality checks. Yeah. All right. Okay. Wow. That was even longer than I thought. Now let's move on with only 2 slides left. There is light at the end of the tunnel for you. IPR enforcement, very briefly. Again, I try to be as briefly as possible. So we do have instruments in place. We have the IPR Enforcement Directive. We are not going to amend the IPR Enforcement Directive. That we have decided already 2 years ago. We are giving guidance on how to interpret IPRED, how national courts, for instance, have to deal with, let's say, dynamic injunctions. We are not going to reform the IPR Enforcement Directive for the time being. It stays as it is. Yeah. However, what we are going to change is the online world, because if you look at where the problems are actually with IPR enforcement, the novelty is really the way that online intermediaries in particular are dealing with illegal content, with counterfeit products. And for that, actually, we have a new instrument that we have proposed as European Commission, the so-called Digital Services Act. That's a proposal of the 15th of December of last year. It's very recent, very fresh. It's a reform of the e-commerce directive. And it should actually identify better what we expect from e-commerce platforms, including classified ad platforms, including social media, what we expect from them actually to avoid the sale of illegal content or the offering of illegal content, in particular of counterfeited and pirated content online. Yeah. So this is a legislation that is already proposed now, that is being discussed in the Council and the Parliament. Now, for the rest, you will see that we have ongoing business. For instance, in the external dimension, we have renewed a version of the counterfeit and piracy watch list, naming and shaming of, or in particular, online bad faith online intermediaries in third countries. Well, that work is ongoing. Possibly the novelty that we have in this IP action plan is the announcement that we are going to create an EU toolbox against counterfeiting. Now, what is an EU toolbox against counterfeiting? Well, first of all, it's something that complements what we have already on counterfeiting. So it's not that we replace something that is already out there. But we are thinking about a recommendation in particular. So a recommendation of the Commission, which means it's not binding. It's something that we recommend the member states and private business to do in the area of counterfeiting. For instance, to share better information. And in that toolbox, then we can explain how to deal with data protection issue, for instance. We also would like to promote cooperation between law enforcement authorities, so that there is more coherence in the way that law enforcement authorities like customs or national police now operate. That's absolutely necessary, because what we see is that too often actually one doesn't know what the other is doing, and too often from the brand's perspective, for instance, you see that we ask brands and we ask also individual law enforcement authorities to introduce data that are already present in other databases, and that's something we have to work on, and we are doing that together with the EU IPO Observatory. Okay, finally, you see under F here the announcements of an initiative in the area of cyber theft of trade secrets. That's a very specific issue, but it's a very important issue. not everyone online can be trusted, as we know, and actually many SMEs in particular are pretty well, careless when it comes to the protection of their trade secrets. And what we are trying to do is to help them actually to increase their resilience, in particular by giving guidance, targeted guidance, how they have to protect themselves against cyber theft of trade secrets, and when they are victim of cyber theft of trade secrets, what they need to do. And there I go to my last slide, which is the global dimension. Okay, there is a little mistake here, fine. So here, it's ongoing business, I would say. We continue, of course, to seek ambitious IP chapters in our free trade agreements. The most recent one is the free trade agreement that we have now with the UK, our former partners in the EU. We also have IP dialogues around the world, including with the Turkish authorities, where each year there is a meeting where issues are discussed, like pharma, like counterfeiting as well. Well, these dialogues will continue. We will also continue to be present in all these international fora, such as WIPO, the OECD, the TRIPS Council. We defend global standards, we believe. We believe, by the way, very much in global cooperation. We are not in favor of only bilateral global cooperation. We believe that WIPO is very important. We believe that the TRIPS agreement is very important. We believe that altogether, actually, we should work to improve IP system to the benefit of our citizens, of our businesses, but at the end, actually, of our citizens. That's not a unilateral issue that we have as EU with one country or the other. We believe in globalization of in general, and also in the area of IP. So we will continue to be very constructive in all these fora. Now, concretely, we are preparing EU accession to the Singapore Treaty on trademarks and to the Beijing Treaty in the area of copyright. And finally, we also pay particular attention to the technical assistance that we give to developing countries. I mean, we have a very strong Africa-EU partnership now, with a strong dimension on IP. That's not so much we give you money and please create a good IP system. It's not only about that. It's not only about creating systems in Africa. It's also about helping SMEs in Africa to deal with IP. So actually the same as what we do in the EU. We want to export that actually as well to African SMEs, knowing, of course, that Africa is a big continent, and we have to choose actually our priorities there, but we are working on it together with the EUIPO and others. And I think that was it. And I will now go back to the audience and to you, Arzu.
Okay, thank you very much, Bear Harry. Thank you very, very much for this wonderful presentation. Probably the most gripping question that comes up during our pandemic lives, potential effects of the COVID-19 on the IP rights. But this is a too lengthy issue to address in this webinar. Let's leave it to another occasion. We have another reason to organize such webinars, maybe. Now, I would like to turn to unitary patents now. Could you clarify when does the unitary patent system start to operate? We discussed about it before also, maybe you remember. Please.
Yes, yes. Yeah, that's a good question. And the one who knows the answer will probably get a bonus. That's impossible to say. But as I said, once we have the ratification finished in Germany, we have the minimum amount of signatures, ratifications of member states in order to start the system. Yeah, and so doesn't mean that from one day to another we can start the system. We have still this initial period that I mentioned to you before, this transitional period in which actually obviously the courts have to be created physically. They have to start their business and they have to appoint judges and all the rest of it, and that still needs to be done. I mean, you can't start a unitary patent system actually without having all these courts up and running, and that will take some time. but we really expect that in 2022 we will absolutely be able to to have the first applications for the unitary patent being processed by the EPO, and the courts will be ready then actually to take cases on the unitary patent. And I should say one more thing. I mean, obviously there was another hiccup perceived, and that is of course Brexit. Because of Brexit, I mean, you may know that one of the branches of the new unitary patent court was supposed to be in London, right? So you had one in Paris, one in Germany, in Munich, and one the appeal court in Luxembourg. But there was also a branch actually supposed to be in London. But we believe that because of the fact that the UK is no longer a member of the EU, that will actually not hinder the coming into force of the system, because simply the cases that we have envisaged for London could perhaps go to the Paris branch. But that's still something to discuss. We are discussing that with the member states, and of course in the context of the overall, let's say, cooperation that we have in the context of the unitary patent. I mean, it's not an exclusive EU issue. We also depend on the EPO in that. We are actually also thinking about a memorandum of understanding with the EPO on this. But that should all be ready by 2022. Honestly, I promise.
Okay. Thank you very much. Our audience may have some questions. Let's turn to them now, and I will read them. Samet is asking, may I learn whether IT systems are used for monitoring geographical indications products in Europe?
Okay, that's a clear question. So for non-agri-GIs, we don't have such a system yet, as I explained. But when we are going to create such a system, I am sure that it will be possible to apply for protection in the EU exclusively through the internet. So you don't need to have any physical paperwork anymore in order to get protection for your geographical indication as a regional organization, right? So that's one thing, but that's the registration part. I think your question is more on monitoring. Well, for monitoring, if it is to monitor infringements, for instance, online, for that, obviously you can use IT systems like artificial intelligence, which is actually done by the brands already today in general. I'm not so sure if that is really specific for geographical indication, but I do believe that there is a place for new technologies, including blockchain solutions, actually, when you want to monitor let's say the lawfulness or the legality of the genuineness of a product, be that online or offline, actually, for that matter. So there are not IT system used in the EU as such, but we very much stimulate actually the use of IT systems by businesses and by national authorities actually to make this whole system of geographical indications more smoothly and more sufficient. Yeah.
Okay, thank you very much. Eda Çataklar is asking, we could not hear your explanations on standard essential patents and funds. Could you please explain why they are important for Commission and what are the specific plans on it? Maybe there was a short internet problem, therefore she couldn't hear you.
Okay, I'm sorry to hear that. I'm sure that was on my side, and apologies for that. Now, what I explained about SEPs and SEPs, first of all, was that it's very important, increasingly important because of Internet of Things, and you may have heard that. And then I explained actually that where we are now, I mean, we have an expert group created 2 years ago, actually, that will soon publish its findings, an expert group, particularly on licensing issues, I would say, on friend issues, so to speak. And in that expert group, we had both the implementers and the patent holders. So the discussions have been quite difficult, I can say, but somehow we come to a product at the end, which is a report, and that report will be published, and it will be published probably pretty soon. Yeah, we also did a study. We conducted a study on essentiality checks by IP offices. So there is a lot unknown about under which conditions you get actually a SEPS, a standard essential patent, a recognized SEP by an IP office, for instance. We don't know much about what are the criteria used by IP offices, and we have done a study now, and the results have been published as well. And the results are actually now discussed with the real world, with the patent community, to see whether everyone agrees or not. So that's the situation where we are now. What are we going to do in the future? That's the real question. Now, I explained that there are two work streams. One work stream is to work together with businesses, continue to work together with businesses and find solutions, in particular on FRAND. Yeah. So it's not creating new law. You don't need that. You need to give some guidance, perhaps, also for businesses, or bring businesses together, maybe by means of an MOU or whatever. You have to bring businesses together and say, okay, this is how we're going to deal with SEPs. Because nowadays there is an increasing uncertainty because there are no clear rules for the FRANDs. I mean, you have the general rules, yes, but the detailed rules are not there. And there are a lot of court cases, in particular in Germany, and we have seen now, you will soon see that there will be a new case before the Court of Justice. I think it's from the court in Mannheim, actually, on the interpretation of the FRANDs, which is actually a follow-up of the Huawei case you may be familiar with. So that is one part. And another part is that overall there is a lack of transparency overall, in particular with the essentiality checks, and we may come forward with a binding instrument that would force more transparency in the market.
Okay, thank you very much. We have two questions. Maybe you can answer both of them. Salih Polater is asking what would be the impact of 3D printer on IP law, and Koray Güven is asking, many thanks for the presentation. Recent decision of the CJEU have given rise a discussion that copyright and design protection may overlap to a greater extent. Is there any strategy in the EC's agenda to align the exceptions to design right with the ones to copyright, particularly taking the advent of 3D printing into account?
Very good. Yeah, thanks. Yeah, that's an excellent question, actually. Now, I was discussing the designs reform, and as part of the designs reform, obviously, we have conducted a study on the influence of 3D printing on the IP system in general and on designs in particular. And yes, there is an issue with the exceptions, of course. And when there is an issue with exceptions, you always have to look how the relationship is between the copyright and the design right. That's a fair point. And whereas on the one hand, I said, if it ain't broke, don't fix it. We do not think that because of 3D printing, there is a huge issue of law. But there is, on the other hand, need for certain clarifications, in particular on the relationship between the exceptions and the way that design law applies to 3D printing, and copyright applies to 3D printing. And we plan actually to clarify that relationship in our designs reform. So it will certainly be taken on board, but don't expect many changes here. Eh? Don't expect many changes. It will be more clarifications than anything else. And it will be rather limited, I would say, even.
Okay. Another question from Salih Polater. What are your reservations about the protection of non-agricultural geographical indications in EU law?
Yeah. Well, we have been working on this project already for many years. The Commission has never come forward with a proposal to create a system of non-agricultural GI protection. The reason was very much internal in the Commission. We did not simply get enough support within the Commission to come forward with such a proposal. If you look at the Council, the member states, we can see that there are many member states very much in favor of the Commission to come forward with such a proposal. Germany, France, Italy, Spain, for sure. But there is also resistance from some member states. I always call them the frugal four. We have the Netherlands, Denmark, Sweden, and Finland. Those countries are not so much in favor of having a GI system, and there are countries who may or may not be aware, but I do believe we have a qualified majority in the Council actually to back such a proposal of the Commission. Parliament has been always a big fan of a sui generis system for non-agricultural geographical indications. But of course, if we take 2 steps back, you have to be fair. For many years, we did not have a system of non-agricultural GI protection in the EU. Has that been devastating? Is there then absolutely no tool whatsoever for protection for those manufacturers of high-quality products, for these premium products, because quality is very difficult to define. But let's say products that consumers are willing to pay something extra for. These companies always can use the trademark system, and they can use the system of collective trademarks. They cannot use, though, the system of certification trademarks, because that we have excluded in the last trademark reform. So an option actually would also be, and that's not excluded, although not maybe too realistic neither, that we say, okay, we reopen the EU trademark regulation, and we just enable regional or local associations to ask for a certification trademark, which is not the same a trademark as a sui generis protection for GIs, but it could be an improvement of the situation as well. Well, all these options are still on the table. We will put them all in the so-called impact assessment that we are preparing, and well, the final verdict will be by the end of this year when we come with a concrete proposal. That is almost for sure that we will come forward with a concrete proposal. It is likely that we are going to do a proposal for a sui generis system, but I would not be absolutely sure. I would not bet all my money on that, because it's still subject to a lot of internal debate.
Okay, thank you very much. We don't have any other question because you explained everything. And thank you very, very much to Mr. Temming for this extensive presentation, and also to our audience for their attendance and their stimulating questions. It seems we will have to tackle with these issues much more in the future. Potential impact of the COVID outbreak, non-agricultural GIs, artificial intelligence, blockchain, 3D printing, and standard essential patents will dominate our agenda. We hope to keep in touch and prepare much detailed programs in the near future. I hope maybe face-to-face in Ankara or in Brussels.
Would be great, Arzu, would be great.
Yeah, thank you very much again, and to Mr. Temming, to Harry, and to our audience. And I'm closing the event, and I wish you all the best and goodbye.
Okay, thank you very much again for your attention. I'm really sorry I couldn't see the faces of those who were actually in the audience. Those are the days. Let's Live today. And I'm sorry that I did not go into too much detail, maybe every now and then, but I'm sure on another occasion we will continue.
Yes, sure, we have to organize another webinar with you. Thank you very much.
Many thanks, and have a nice evening. Goodbye to all of you. Ciao.